Hello, and welcome to Overheard, the Foreign Policy Research Institute monthly podcast that explores the national security implications of intelligence activities, irregular warfare, and political warfare. My name is Phil Wasilewski, and I am the director of FPRI Center for the Study of Intelligence and Non-Traditional Warfare. And today we're going to discuss intelligence activities from the different perspectives of protecting national security secrets and honoring press freedoms enshrined in the First Amendment. Is it ever okay for journalists or the free press to print national security secrets? Does the First Amendment have precedence over all laws, or do statutes such as the Espionage Act take precedence when a press matter discusses national secrets? What is the difference between a person who passes classified information secretly to a foreign power, an act known as espionage, and one who passes such secrets to a journalist or even self-publishes them online? Where do we draw the line regarding such questions? Joining us today to discuss these questions are three distinguished guests from the worlds of national security affairs, jurisprudence, and journalism. Our first guest is a distinguished journalist, Jill Dougherty. Jill is currently an adjunct professor at Georgetown University Center for Eurasian, Russian, and Eastern European Studies, and a global fellow at the Woodrow Wilson International Center for Scholars in Washington, D.C. She served as CNN correspondent for over 3 decades. Her area of expertise is Russia and the post-Soviet region. Jill was CNN's Moscow bureau chief for almost a decade, but she also served as a White House correspondent, foreign affairs correspondent covering the U.S. State Department, U.S. affairs editor, and managing editor for CNN International Asia Pacific based in Hong Kong. She currently is a CNN on-air contributor commenting on Russia-related issues. Our next guest has been with us before, George Croner. George was part of the first Overheard podcast a year ago when we discussed issues related to the renewal of Section 702 of the Foreign Intelligence Surveillance Act. The act was renewed, and George, we have to believe part of the reason for the renewal of Section 702 was your eloquence in defending it during our podcast.
I'm not going to take any dispute with that, Phil.
Okay. George is a former principal litigation counsel at the National Security Agency and is currently a non-resident senior fellow at the Foreign Policy Research Institute. He is also a member of the Advisory Council at the Center for Ethics and the Rule of Law at the University of Pennsylvania. He's written over 50 published articles and appeared on multiple media platforms discussing foreign intelligence issues, including the tensions that can arise at the intersection of journalism and the protection of national security. And our third guest is another lawyer, Jim Petrila, who will help us sort out legal questions during today's discussion. Jim served as a legal counsel with both the National Security Agency and the Central Intelligence Agency for almost 4 decades. He also served in the legal department of the National Security Council at the White House, and currently is an adjunct faculty member of the George Washington Law School, where he teaches courses on national security law. The starting point for our discussion on secrets and press freedoms will be the plea deal this June in a federal court by Julian Assange regarding charges of conspiracy to obtain and disclose national defense information. Assange, who is not a U.S. citizen, is the controversial founder of Wikileaks. In an article published in July by the University of Pennsylvania Center for Ethics and Rule of Law, our guest George Croner wrote that, quote, "The Assange plea agreement should signal that the government no longer considers the media immune from the consequences that espionage statutes, at least on their face, contemplate for such conduct." However, others disagreed, and as George also noted in his article, the New York Times wrote that the plea deal sets a chilling precedent that will send a threatening message to national security journalists. Today, we're going to discuss which view might be correct. I will ask Jim now to provide you all and our audience with a basic understanding of the Espionage Act, how it functions and how it's been used in the past, what were the particulars in the Julian Assange case, and what the court said regarding his conviction to kick off our discussion on this subject. Jim, welcome.
Well, thanks, Phil. And I'm, delighted to be with two such distinguished people as my former colleague George and Jill. It's very nice meeting you, however, even if virtually. The Assange case is such an interesting one, and Assange himself with WikiLeaks went through a little bit of a journey where initially he was viewed as a free information, free speech absolutist and kind of a hero. And then when he became involved in kind of the U.S. political process back in 2016, people's views of him changed to a certain extent. His publication of the Hillary Clinton emails created a big, certainly had some impact on the election. What was interesting was the view of people that initially had applauded him for his free speech advocacy changed when in 2017 he published the Vault 7 leaks, something for which Joshua Schulte, a former employee of CIA who worked in their computer exploitation area, was ultimately arrested, and he was convicted in July of 2022. And given the seriousness of what he did, and in conjunction with that, Assange's publishing what Schulte lifted in WikiLeaks, and the damage that caused, Schulte was given a 40-year prison sentence a couple of years ago. And Assange was not prosecuted in that case. All right. So what we're left with then is, how did this plea deal go down? Assange was initially indicted in March of 2018 in the Eastern District of Virginia in connection with the Chelsea Manning leaks. He was subject to it was an 18-count indictment in a superseding indictment that was issued in June of 2020. In fact, nearly 5 years to the day before he pleaded guilty. During that time, he was in custody in the UK after he escaped from the South American embassy that he was hanging out in. And I'm drawing a blank on whether it was Bolivia or
Ecuador.
Ecuador, yeah.
Thanks, Jill. So after that, he was detained in the UK, and he fought extradition for a number of years. The issue was finally resolved in June of 2024 when he pleaded guilty to one count of conspiracy, again, in connection with the Chelsea Manning leaks, which is where WikiLeaks actually, exploded onto the scene. Now, he pleaded guilty to one count under 18 U.S.C. Section 793. And what he pleaded guilty to was being an unlawful possession of conspiracy to be in unlawful possession of U.S. defense information, which in today's world pretty much means classified information. All right. Now, if you take a step back and look at the ways under which people can be prosecuted for unauthorized possession of classified information, 793 involves the gathering, transmitting, or losing of defense information. It has A through G in terms of sections. It dates back to 1917, the original Espionage Act, and it was the first time that the U.S. tried to put criminal sanctions on unauthorized access to transmission of defense information. 793 focuses on people who are authorized to have access to classified information but misuse that authorization, and those that are not authorized but are not foreign powers and come into possession of information. Pretty straightforward statute. The purpose of it is to ensure that people like Chelsea Manning can be prosecuted when they misuse information. The requirements are the information has to be respecting the national defense of the United States, and it has to be misused with intent or reason to believe that the information will injure the United States or will be used to the advantage of a foreign nation. Pretty straightforward. Then the other part of this general statute, there are two others that are worth mentioning, I think. 18 U.S.C. 794, which is the typical espionage statute, which involves providing, again, defense information to a foreign power. And a foreign power in this case can include a faction, which is to say, like a separatist group, a secessionist group. But for 794, which has much stiffer penalties, death if the provision of information results in the death of a U.S. asset, and then Section B of 794, death if done during time of war. So 793, 794 are the two basic ones. And then, in a nod to George, Section 798, 18 U.S.C. 798, specifically deals with what's called comment. Now we'd call SIGINT, communications intelligence, signals intelligence, and 798 is unique in this trio of statutes, in that it is the one statute that specifically outlaws publishing of information. And the reason for that is because of the sensitivity of cryptologic information and SIGINT information. It was a result of a couple of things. A guy named Jonathan Yardley publishing a book called The Black Chamber about U.S. decryption efforts through World War I, and then the famous case where the Chicago Tribune published the fact that the U.S. government had violated or had broken the Japanese naval code.
Jim, a question for you. Private Manning turned over to WikiLeaks tens of thousands of documents, CIA reporting, NSA reporting, State Department diplomatic cables that were never to have seen the light of day, and he was court-martialed and convicted for this. But Julian Assange, who published it on WikiLeaks, is not a U.S. citizen. How does the Espionage Act apply to him, even though he's not an American citizen?
Well, the fact that he was unauthorized to receive the information that Chelsea Manning was providing him puts him four square within the criminal provisions of the statute. So the statutes like this have extra-jurisdictional applicability, and you don't have to be a U.S. person to get caught up in it.
In fact, the reality is that if you theoretically would have nothing with which to charge a foreign spy that you caught in the United States if you couldn't actually charge them with violations under Title 18. So as Jim says, they have that extra-national application.
So as long as we can get hold of the person, we can prosecute them. Is that the crux of it?
Right.
Yes.
Yeah.
All right.
Yeah. No, absolutely.
George, you after the plea deal of Julian Assange, you wrote an article that, as I mentioned earlier in the introduction, that said this is a great step forward. Tell us what's the crux of your article and the crux of your argument regarding this plea deal.
Well, I have been interested and bedeviled by the leaking of classified national security information for 40 years, going back to my time at NSA. I wrote my first article about Assange when Assange was charged by the government back in 2016. It did not, in that indictment, did not include any violations of the Espionage Act. But the government, as Jim pointed out, certainly upped its game in 2019 when it issued a superseding indictment that indeed did charge him with violations of Section 793 of Title 18, which is the Espionage Act. And it was at that point in time that I wrote my first article on the Assange indictment and basically wondered aloud whether that indictment signified at long last a different approach from the Department of Justice in terms of how it would deal with those who leaked and perhaps published classified national security information. Subsequently, that article was developed into a chapter, frankly, that's now in a book that's being released on Friday, I think it is, by the Oxford University Press on journalism and national security. And as Jim pointed out, the Assange case sort of wandered around in sort of this extrajudicial area for years because Assange was outside the reach of the United States in Britain. And most of the litigation that went on all had to do with whether or not he could or would be extradited. But finally, frankly, somewhat surprisingly, earlier this year in June, it was reported that Assange would in fact take a plea, and that plea would not be only to the counts in the indictment that did not involve the Espionage Act, but would plead guilty to violating the Espionage Act as part of a deal in which he would be then released with essentially time served, no additional jail time, which sparked some outrage from conservatives or those who thought he should have been prosecuted more zealously, although he had in fact spent 6 years in prison while the extradition process worked its way out. And I then wrote the article that was published by the Center for Ethics and Rule of Law at Penn, in which I took the position that the plea agreement that Assange entered into was a win for the government, which not everyone agreed with at the time, and in fact established an important precedent. Whether or not the government actually uses it much going forward remains to be seen, but an important precedent that for the first time, a criminal conviction had been obtained against not the leaker, but the publisher of classified national security information, in this case, Assange. And my view was the reason that it represented a victory for the government was that, first, there had been a perception. Well, let me back up for a second. The day after Assange pled guilty, Charlie Savage, who's been the principal New York Times national security pundit for years, wrote a doleful article in the New York Times, lugubriously complaining about how Assange's conviction represented a terrible blow to the First Amendment. It should never have been allowed to happen. The only thing that made it even remotely palatable was that at least the case wasn't tried to verdict and had gone to the Supreme Court, so that you had a Supreme Court decision. But according to Savage, for the first time, I think these were his words, for the first time, there had been there is now a criminal conviction for the purposes of press freedom. He was performing journalistic acts, and someone had been convicted of violating the espionage laws in the performance of journalistic acts. I thought that was a rather significant outcome, as expressed by Mr. Savage, because in my view, for the first time, it perhaps offers some deterrent effect to the leaking that goes on and the subsequent publication of classified secrets. And secondly, it removes the idea, which again, Charlie Savage acknowledged, the widespread assumption that applying the espionage laws to journalistic activities was just prophylactically unconstitutional. And those are the reasons that I felt that the Assange outcome represented essentially a win for the government.
Thanks, George. And my personal opinion is I agree with you, but I realize that opinion is not shared by others. Jill, could you tell us why, in general, the Fourth Estate might feel a little bit differently about this issue than George does?
Well, I think, and again, I'm not a lawyer, so I feel a little outclassed here, but I would say, putting my journalist hat on, I would say, number one, freedom of information, First Amendment, and then especially this idea that the public needs to know this, that whatever, is being revealed is so important that maybe even you have information obtained illegally, but you still have, as a journalist, the responsibility and maybe even the right to disseminate it. And then, there are times when governments, of course, cover up crimes or they want to prevent being exposed in an embarrassing way for what they've done. There are a variety of reasons. So I think as a journalist, you look at this and you say, there are cases, maybe they're not really, really common, but there are cases where the public's right to know trumps the government's ability or let's say the right of the government to control that information. I think that's the closest I can come.
Okay. Question for you all. Now, the black and white portions of this, of disclosing classified national secrets openly, are pretty clear. 99.9% of our journalists are not going to write a story with accurate information about how to build an atomic bomb or publish the top 10 software failures of the F-35 or things like that, clear violations that will harm national security. But in terms of foreign policy, there can often be a natural tension between the government that wishes to conduct international relations at times in secret and the press that wishes to report what the government is doing. We look at some cases such as the Pentagon Papers. During the Johnson administration, the documents that led up to the Vietnam War were collected in one volume to provide policymakers a review of what had happened before. They were then leaked to the press, published by the New York Times. And although they were secret, they showed quite a different view of the internal deliberations of the government as opposed to the public view that was then being presented by the current administration. In such cases, what trumps the national security classification stamped on the papers or the public's right to know that Jill was just talking about? And George, I'll start with you and then go over to Jill.
Well, I unabashedly, obviously, for years have supported the idea that the elected representatives of the people get to decide how the nation's security is protected. And those elected officials have a system in place that classifies national security information. And the Congress has passed a number of laws setting out the circumstances where the disclosure of classified information is unlawful. So, like any other part of what makes the country work in terms of abiding by statutes duly passed by elected representatives, when someone leaks classified national security information and it falls within the purview of those statutes, they can and should be prosecuted. Now, the difference, the rubber meets the road, as Jill says, and no one would ever dispute that, for example, the person that provided the classified information, say, to the New York Times, can always be prosecuted. The question is whether the Times can be prosecuted. And those instances have been non-existent, frankly, at any point in time. I think of two particular examples: the disclosure of the Stellar Wind program back in 2005 by the Times, and subsequently the disclosure by the Washington Post of the Snowden revelations, both of which involved the publication of classified communications intelligence information. The question is, why weren't they prosecuted? Certainly the people who provided the information, if the reason Snowden's in Russia right now is he'll certainly be prosecuted if he comes back, but Bart Gellman gets a free pass and gets to write a book and make a lot of money off it. And James Risen and Eric Lichtblau published the details of the Stellar Wind program, and again, nothing happens. So again, we have these statutes on the book. The government has been incredibly placid about how it approaches this problem, even today. And believe me, after the Assange plea agreement, there are a series of restrictions codified in the Code of Regulations by the Department of Justice that limit the ability to even issue subpoenas to journalists trying to get access to their sources and so on. So we're not in danger of any overwhelming wave of the Department of Justice sweeping down upon the Fourth Estate and issuing subpoenas. But at some point in time, I believe that a better balance needs to be struck. And in my view, the Assange case at least represents some step towards achieving that balance. I might point out, by the way, that in terms of the Pentagon Papers case, that case ended up a 6-3 decision. The sole issue there was prior restraint. Could the government enjoin the publication of the Pentagon Papers? It ended up 6-3. The three dissenters clearly not only would have allowed the prior restraint, but certainly would have allowed prosecution of the New York Times subsequent to publication. Two other judges that voted in the majority, Stewart and White, both said in their concurrences in that case that while they could not vote along the grounds of permitting a prior restraint, which they did believe violated the First Amendment, that they would have been perfectly okay if the government had decided to prosecute the Times and the Post after publication for violations of Section 793 of the espionage statutes. So arguably, there is a case out there, the Pentagon Papers case, almost 60 years old now, 50 years old anyway, where there theoretically would have been a 5-4 decision in favor of allowing the Times and the Post to be prosecuted post-publication. The government simply did not pursue that avenue.
Jill, somehow I've got an idea that prosecuting the Post and the Times and other newspapers for these articles is not a really good idea in the eyes of some journalists. Why would that be? What's the other side of the coin here?
Well, I think you have to go back to, the Fourth Estate and why it's there. And I think there's a tension built into our system where journalists will try to get more and more information, and the government sometimes, and especially in modern times, wants to control that because it's very important. And as you pointed out, some of the most controversial points come when you're talking about foreign policy, not just, let's say, a military secret that suddenly is out, but, where are we going? What is the policy in a certain area? And I think also that issue, well, let's take a journalist who really tries to do that. The journalist would have to, usually they would talk with an editor, because most journalists actually work with an organization that has an editorial function. There are editors, there are people that you talk with, people who question you and who have a lot of experience. So a lot of the time, it's not just one individual. Pentagon Papers was different because, I think Ellsberg was with MIT. He wasn't a journalist. But with journalists, you're usually with a structure. And so it becomes very, very complicated, because I think a journalist could make the case that if the United States is changing policy, even if the United States government reflects the people, that ultimately the people should know this in order to be informed about the policy that the government is taking. Now, I think it's a very complicated subject, because the people don't always know the context or the facts going into some type of decision by the government. But I think that's how a lot of responsible journalists would look at it, that it's their duty, to go as far as they can to get information and give it to the public.
Jill, follow up on that. George just made the point that we have elected officials who make the final decision on what will be classified and what will be not. And this is done via various different regulations and laws we have regarding the original classification of classified documents. Although you have editorial boards, none of them are elected by anyone. Why should their judgment at times trump those of elected officials?
Because those journalists and their editors are supposedly directly representing the people. It's not that they are edited. They have a very, a sacred function to carry out in our democracy. And they do it with certain rules. Now, these are not laws, but they are commonly accepted rules of behavior, ethical norms that journalists have, and most responsible organizations have them literally written out, and they will follow those knowing that it's their job to push. It might be the government's job to push back, but the journalists will try to push as far as they can, again, because they believe that, they're responsible for the public's right to know.
So Phil, could I add one point here? And this is based on, in part, on the class that I teach at GW. It's called Crisis and Legal Controversy at CIA. To the points that George made, one of the issues of Stellar Wind was that you could make a pretty cogent argument that it was a clear violation of the Foreign Intelligence Surveillance Act. And the fact that the briefing of it was limited to the so-called Gang of Eight, which is the two heads of the majority-minority head in both the Senate and the House, and then the two comparable on the Senate Intelligence Committee and the House Intelligence Committee. So when you have a program that is that controversial and kind of challenges one of the basic assumptions of the Foreign Intelligence Surveillance Act, then I think that, I give some credence to Jill's point that there is, painful though it is for me to say, given how long I, thought things like this were horrible. There is a point to that kind of article. Similarly, with the reporting that Dana Priest did with, on the black site program. All of which to say is that these issues are extraordinarily complex. And I think that one of the dangers of this potentially being like open season on newspapers that you don't like is that it can lead to selective prosecution. It can lead to, the kind of assault on the First Amendment that a case in a civil context, New York Times versus Sullivan, was intended to prevent happening. And George, we've discussed this on a number of occasions, but I think that they're two very, very different and each relevant point, and how you balance them. I don't know.
George, do Jill and Jim have a point, or does through their responses put us on a slippery slope of letting journalists decide ultimately what the government can and cannot keep secret?
I think the latter may be true, but to me, there is a way around that. I'll go to the first point of the press has sort of its own editors and so on in place, and they exercise judicious consideration of what it is they're publishing. When the Stellar Wind program was actually then disclosed by the New York Times, the executive editor at the Times at that time, Bill Keller, said, and I quote, "We satisfied ourselves that we could write about this program in a way that would not expose any intelligence gathering methods or capabilities that were not already in the public record." How on God's earth did Bill Keller decide he was in a position to make that evaluation? When I wrote my initial Assange article, I said that as far as I was concerned, Bill Keller had as much right to make that decision about the nation's communications intelligence activities as the director of NSA had of deciding what kind of advertising campaign would best promote the New York Times circulation. So I just don't see that there. The other point I would make here is I might be more open to the idea that there should be more play here, because I've certainly heard the arguments that, why are you going, you, the government, need to keep your house in order. If you can't protect your secrets, it's not our job to do that. We're the press. We're supposed to be ferreting out what it is that you're doing. So don't blame us. And I would say, okay, if we're going to turn this into sort of that kind of competition, I would agree with that if the government could then go ahead and subpoena you to find out your source, not prosecute the journalist, not prosecute the press, the Times or the Post. For example, go to Bart Gellman and with a subpoena that says, give me Edward Snowden's identity, or whoever it was that in fact has broken the law. But of course, there is no federal shield law, unlike there are in many different states. There is no federal shield law, although Lord knows the Fourth Estate has been begging for one for the better part of a half a century. But instead, they resist any effort, any notion at that. And in fact, as I say, literally 2 years ago, I wrote another article when Merrick Garland handed out a new set of restrictions that further tamped down the Justice Department's ability to pursue leaks through the execution of subpoenas for reporters sources and so on. So as I say, it just seems to me the field is way out of whack in terms of how you protect the nation's secrets.
George, with StellarWinds, which was an intelligence collection activity, we have pretty clear guidelines that this is in the intelligence realm. But as was mentioned a little bit earlier, we also have foreign policy decisions, as Jill said, that the public may be made aware are coming. Now, Jim, when you and I served on the National Security Council, the Obama administration decided to change our policy towards Cuba. And as you know, this was done very secretly. There were only 2 senior people who were involved in this. It did not go through the normal NSC process. And it was quite a surprise when it was announced. And part of the reason for that surprise and that secrecy is the administration knew that if it was leaked, they would face a lot of resistance, not only in Congress, but within their own administration. Now, I was no big fan of that decision, but should not the president be able to conduct foreign policy in secret when he believes he needs to? Because, again, he is elected by all of the people. And as you know, foreign policy deliberations can be classified up to top secret, depending on their sensitivity.
So, let me take just a quick one at that, and then Jill, I'm really curious about your response. I think that kind of situation goes to George's point, where if an administration is engaged in a sensitive policy matter that is going to change the direction that the country has followed for a long, long time, it's really up to the administration to make sure that they keep their house in order. And that, and the Cuba case was done through pretty tight compartmentation. I think what happens often is in discussions like this, as word gets out, people that are opposed to it are very effective at calling up people like Jill and her colleagues and saying, you're going to believe what these bozos are up to next. Or maybe something a little more respectful than that. And so, part of this whole complicated dynamic is the way in which senior people use the media, the fourth estate, in order to carry out policy disputes. And I think to the extent that you have administrations that are not aligned, you have a greater number of leaks because there's more controversy that goes along with that. And since a lot of that stuff is classified, that goes to George's point of, does this then become fair game for a criminal investigation, or, subpoenaing Jill to find out who it was from DOD that called her up that irritated the Secretary of State?
Jill, what are your thoughts?
Yeah, I was going to play the devil's advocate, or at least kind of try to get at this in a different way. That phrase that you used, use the media, I'm not too sure that's exactly what happens, at least with responsible organizations. Let's say that a leaker comes, and this is now a political type of leaker, that they're discussing some, change in the policy on Ukraine or something like that. That would be extremely interesting for the media to know. But when the media, and I'm not on these committees, but when responsible people in the media look at these, they often think, what's the motivation of this person? Are we being exploited? Or, as you were using the phrase there, are we being used by somebody? And so, and because they are not naive when they are making these determinations. This goes way back when information has been leaked, and especially like the New York Times had to make some very critical decisions that could affect the United Nations security. So the teams look at it and decide, number one, is this legitimate? Is it true? Why would this person want to give this information to us? Is the need for the public to know so great that there is a purpose in doing this? Are we being impartial? I mean, I think that's a big question. What else? You're not being a tool of any government, even indirectly, and certainly with Assange. If you look at Assange, there are multiple reasons to suspect what he was doing. That's my personal opinion. So I do think motivation matters.
George, your comments.
Well, first of all, I'd say that the kind of foreign policy issue that you're talking about with Cuba and so on, I think that would be a stretch under the espionage laws anyway. I'm not so sure that that's national defense information. I guess broadly construed, it might be. But as I said, my focus that I have written on over the years and so on, because of my NSA background, has been disclosures relating to the communications intelligence activities of the United States, where there is, as Jim pointed out earlier, a specific statute passed 30 years after the original Espionage Act in 1950, and specifically proscribes publication. So because, as Jim pointed out, the decision was that type of information was both vulnerable and vital to a unique degree. Interestingly enough, when 798 was passed in 1950, it was endorsed by the American Society of Newspaper Editors as being a well-crafted piece of legislation, again, devoted to protecting this particularly unique type of information. But on the broader terrain that Jill has raised, where, again, statesmanship issues, foreign policy issues, trade issues, things like that. I mean, I'm not nearly as draconian as I may have sounded with respect to some of my earlier comments, because again, I focus on Assange's case. I see a perfect basis for his conviction. I don't know whether he would have been convicted at trial. Who's to know? As I said, the utility of this, from my standpoint, the reason I wrote the article was because, again, it offered a deterrent impact, and it at least sent a signal out there that the First Amendment doesn't prophylactically protect journalists in all circumstances and all cases. But there are plenty of areas, like Jill has identified, and Jim as well, where I'd say it's a much tougher call than I would have found with Assange or with any 798 issue.
Well, I'd like to wrap up our discussion with one question for all three of you. And that is, as either national security professionals or as journalists, but also in common as American citizens, what are our rights and also what are our responsibilities regarding the public's right to know and the First Amendment versus the public's right to be protected, especially when those protections often come about via sources and methods that must be kept secret to be effective? Jim, I'll start with you.
Well, Phil, that's a dilemma. That's a dilemma, and I think that since you have core values that are in tension with each other, the context matters so much. It just becomes extraordinarily important. I think that since bureaucracies have a tendency to overreach, right? Administrations have a tendency to overreach. And now with the recent immunity decision that the Supreme Court came up with, the executive branch has even, made feel even more emboldened to overreach. And one of the defenses against that overreach are, people like Jill and her colleagues, professional journalists who feel deeply about the values of the country, about the Constitution. How do you weigh these things? How do you weigh these things? And I guess where I come out maybe a little bit less so than George is that the use of Title 18, the criminal code, is a pretty heavy tool. And, I am fine with Assange. I'm fine with some of the ways in which subpoenas have been used in specific identifiable cases where the stakes are so high because the information leak was so damaging. But it's it's something where you need a scalpel rather than a hammer.
Thanks, Jim.
How's that for talking out of both sides of my mouth?
That's
My law school would be proud.
Thanks, Jim. George, what's your viewpoint?
I'm largely come out where Jim does. I feel obviously, as I expressed in the Assange, that the pendulum had swung. That frankly, in a reaction, Jill's absolutely correct. If anything, the Church and Pike Committee hearings of the 70s made it clear there was a lot of bad stuff going on in the intelligence community at the time. And since that time, perhaps that's been the whole point, that the pendulum moved largely because of the disclosures that there had been so much wrong. I feel like from my personal standpoint, it had swung too far to one direction. And to the extent that Assange signals that it's coming back a little bit, or at least sets a measure there where it's like, if we go too far here, there can be theoretically criminal liability. I absolutely agree with Jim. It shouldn't be used as a truncheon. It should be used as a scalpel, and a very careful scalpel, if used at all. But as I said, I'm not holding my breath for the next Department of Justice prosecution of any media entity post Assange. But at least Assange is there. So that's sort of where I am.
Thanks, George. Jill, you get the last word on this.
Oh, thank you. I'm so glad. My background is studying Russia, and it's not exactly a good example of, protecting the public's right to know. So I kind of take it from that viewpoint. What's the worst that could happen? And so coming back to the United States, the worst that would happen is that the First Amendment would be put aside, and the government simply would decide what the people need to know. They don't need to know this. They don't need to know any changes. They're not sophisticated enough. We've got so much information, they don't, et cetera. And that would be really a nightmare scenario. But I think Jim and George are right that this is really more complex. So I don't think you can have an overriding rule, but I think you can have principles. And the principles to me are unchanged, that we have a First Amendment for a reason, and we have a fourth estate that exists in order to protect the rights of our citizens to understand what the government is doing. It's their government. Now, that, I think, it puts the media in a role between government and the people, almost like, I'm not going to say an interpreter, but to a certain extent, it kind of is. The New York Times or whatever will delegate journalists to research a certain question. Now they know a secret is almost out. And should we do this? So they will have a whole team who will try to research what are all the issues, what are the implications. And then they have to make a decision. But I think it's important that they continue to make that decision. And that said, it puts enormous responsibility on journalists. And that's one of the concerns that I have, that there are ethical journalist organizations and there's some unethical. I wouldn't even call them journalists, but they're doing, as I think the phrase was, journalistic acts. So, they're acting as journalists, but they're not. So it's always going to be, in my view, a tenuous balance. But there's a reason that it was set up in the beginning, and it's going to be tension for a purpose.
Well, Jill, George, and Jim, I want to thank you all for appearing on our podcast and providing our audience with a fascinating discussion about the laws that guard both our nation's security and our freedoms. I don't think we've solved during this podcast the conflict between the government secrets and press freedoms, but I think we certainly worked out that they need to be solved on a case-by-case basis by people and responsible persons informed about both sides of the issue. And I thank you again for informing our audience about both sides of this issue. Now, speaking of our audience, as always, we want to thank our Overheard podcast audience for listening. If you enjoy these podcasts, please visit the Foreign Policy Research Institute website at fpri.org to subscribe to our mailing list and to learn of future podcasts. Please also consider becoming a member of FPRI and donating to it to support our efforts to provide the public and policymakers with fact-driven, nonpartisan analysis about the most pressing foreign policy and national security issues facing the United States. We hope you will join us next month for another episode of the Overheard podcast. Goodbye.